Well, many thanks for coming this morning to my first press conference as Lord Chief Justice. I've been Chief Justice now for just 2 months, so it's still very early days. I took on the job because I thought I might have something to contribute and could build on the work of my predecessor, Lord Thomas. The job has 3 main components. First, as head of the judiciary and president of the courts in England and Wales. Secondly, to sit as a judge, particularly in cases of public interest. And thirdly, with the Lord Chancellor and Senior President of Tribunals, to oversee the courts and tribunal service which runs and manages all our jurisdictions. There is a huge amount to do, but there are 2 things that I have been particularly concerned about. To increase awareness of what judges do, together with their centrality in maintaining the rule of law, and to secure the reforms necessary to bring the working of our justice system up to date. Independent and open justice and a free press are both fundamental to a society that values liberty under the rule of law. Pressure of time makes it difficult for you and your colleagues to report more than a few cases here in the High Court and Court of Appeal, or up and down the country in the magistrates, Crown, county and family courts, or the tribunals. But most people get their knowledge of judges from the reports they see and read, inevitably the biggest and most newsworthy cases, or from TV and film dramas, which are fictional. So I doubt whether most people appreciate the nature of the work done by our judges on a day-to-day basis. Our unpaid magistrates deal with the majority of criminal cases and also many family cases. We have almost 600 professional district judges who deal with criminal cases and who decide the majority of civil disputes involving individuals or businesses, as well as many family cases. We have a roughly similar number of circuit judges who preside over cases in the Crown Court and who hear the larger civil and family disputes. And there are tribunal judges resolving a wide range of disputes, including many between the individual and the state. Nobody should underestimate how difficult and harrowing it can be to deal regularly with family cases concerning child protection, or criminal cases involving serious violence or sexual abuse. Our judges work incredibly hard, making important, often life-changing decisions, day in, day out, in difficult circumstances. What goes on in court is only part of what a judge has to do. There are long hours out of court, away from the public gaze. I want people to know that. Their daily diet gives them a uniquely broad insight into what is going on in society, especially when things are going wrong. They are a pretty remarkable group of women and men who put public service above personal gain. I believe greater understanding of what they do will lead to greater respect. Of course, judges must earn that respect and should not be immune from criticism for their decisions. But fair criticism is different from abuse. By this I mean those cases where judges face a torrent of personal abuse for decisions they have made, increasingly online and in social media, and a growing number of cases where judges are threatened and physically abused. Some is calculated to intimidate judges individually or collectively, and such abuse is capable of undermining the rule of law. Judicial independence and impartiality is at the heart of the rule of law. So I want to build on the work already being done in schools to enable children to learn about the justice system, the rule of law, and the independence of the judiciary. Lesson plans are available, and perhaps it is something worth focusing on more. We have over 100 diversity and community relations judges visiting schools and working in their local communities and supporting school visits to their courts. Many more judges assist. This is unsung work of great value. Now, I mentioned the reform programme. This is a £1 billion, 6-year project to which the government has given its commitment to bring our courts and tribunals and our administrative practices up to date. I'd like to explain why this programme is so important to the administration of justice. It has 3 broad aims. First, to make the administration of justice more efficient. Secondly, to improve access to justice. And thirdly, to improve the conditions for the public and for court staff and professionals and judges. It is quite remarkable that towards the end of the second decade of the 21st century, many of our courts still operate on paper-based systems. That is changing. A digital case system has been introduced into the criminal courts over the last 2 years, which has already saved the need to print 33 million sheets of paper. A parallel system is being rolled out in the civil courts. Many routine cases in the magistrates' courts, fare evasion, traffic offences and such like, are now being dealt with online. This is really just the beginning. It is transformational and will make dealing with our courts and tribunals for individuals, businesses and lawyers alike quicker and simpler. Improving access to justice is at the heart of the reform programme. Pilots for dealing with divorce and probate online are working well. So too is the online money claim service. When we reach our goal, it should be possible for a very large number of civil disputes to be resolved using online facilities with appropriate judicial input when it's needed, but rarely requiring the parties to attend court. And an example of simplification is a new online help with fees service, which takes about 5 minutes, replacing a 26-page form. There will be many more, which together add up to dramatic change. And we aim to improve our buildings. Some are in a terrible state, and our technology, in particular, to make the conditions of those who work in and use the justice system better. So, as I've described, I'm taking over at a time of great change for our world and the way we serve society, and with much cause for optimism if we can get it right.
Thank you. Martin.
Martin Bennett from the Evening Standard. One of the criticisms that's been raised by a former minister in particular was that you're responsible for the prisons crisis and washed your hands of the prison crisis, have not sentenced too many people and so on. What do you say to that, first of all, in terms of promoting greater public understanding of what you do? And secondly, from your experience with people that are seen coming into the criminal courts, and particularly the younger offenders, are there things that you as judiciary see that could be done, not necessarily by you but by others, to prevent more people coming back in the way that they are doing?
Well, it's well known that the prison population has broadly doubled since 1993. It's been relatively stable over the last 4 or 5 years. The public figures suggest that there has been an increase in sentences, particularly over 4 years, but a decrease in sentences at the lower end, and quite importantly, a marked reduction in the number of young offenders going into custody. Now, as you appreciate, the statutory scheme that governs sentencing requires all other options to be considered first before custody or imprisonment for adults. And that is what is at the heart of what judges do. As is also well known, Parliament has increased the sentences for a number of offences, particularly sexual offences, in the last 15 or so years. And judges are required to sentence not only within the statutory scheme, but also in accordance with the guidelines that are issued by the Sentencing Guidelines Council. That too is a statutory requirement, and the Sentencing Guidelines Council, as you know, consults widely before identifying the appropriate ranges for different categories of offence. So judges are doing what Parliament has required them to do in sentencing. There are various areas where there are quite heartening signs, and as I've mentioned in particular, the reduction in the use of custody for young offenders.
Brian and Owen. Brian.
Going back to your...
So could you...
Yes.
I think that's a famous for LexisNexis. I sat next to a High Court judge who said, there's all this talk of £1 billion. And he said, what are you going to do for fighting for legal aid on the basis that he has defendants in murder cases trying to defend themselves? And in terms of buildings, if he was the Lewes flood dripping into the jury room and he is expected to run the court with respect, I mean, how much are you going to be driving and oversee that this money is actually used?
Well, there are two questions there. So far as legal aid is concerned, that of course in the end is a matter for the government, and as you appreciate, there is a review underway of the legislation on legal aid, which the government announced, I think, 3 or 4 weeks ago. So that's something which is underway. The government will consider all representations it gets and then report sometime in the summer. So far as the condition of our buildings is concerned, I mentioned in my statement that some of them are in a dreadful condition. Some of them are magnificent. Some of the newer buildings are as good as any working environment. The court service is now ensuring that every penny of the budget allocated for repairs is being spent. It came as something of a surprise to me recently to learn that for some years at least, the allocated budget for repairs wasn't completely spent, but that now is happening. The second thing is that I'm very conscious that there are in many of our courts a number of problems which are relatively minor and shouldn't take a great deal of effort to sort. One of the first things I did on becoming or being announced as Chief Justice was to speak to the Chief Executive of HMCTS, the court service, and ask that a fund be found to spend on relatively minor but important repairs, and that it should be made available and spent this financial year. I'm happy to say that she was enormously receptive to that, as was the Lord Chancellor. And so we have secured a fund which is being allocated as I speak. All of the courts across the country were asked to bid for money to deal with these relatively minor but very irritating problems in some of our courts. The allocation is underway and it will be spent by the end of the financial year.
Just two points on that. One of which, when you meet, how concerned are you about legal aid? Will you be, on behalf of the sort of judiciary, putting in anything to the review?
We've been asked to comment, and we will comment. At this stage, it's premature for me to indicate what those comments might be.
But generally, when you look at advising litigants in person, is it something that concerns you when you're taking over the judiciary?
Litigants in person can be a problem for judges, but not always. And it's quite interesting that we now have quite a lot of evidence. It's anecdotal more than properly empirical, that suggests that litigants in person don't necessarily clog up the courts. Some shorten cases, others lengthen cases. But as a general proposition, it usually assists judges to have professionals in front of them, if that's at all possible.
Could you put a figure on the fund? How much was allocated for these?
Yes, initially 5 million.
Next, Owen.
Owen from The Guardian. You talked about, obviously, some of the money is going to be spent on online justice. I mean, how far do you envisage online justice going? At the moment, it's being dealt with relatively minor traffic offences and such matters. Are you worried that the use of virtual courts are going to mean that you have a court in which there's no judge, no lawyer, and possibly no defendant? It's all going to be done online. What does that mean for transparency in justice?
But again, I think there are two points there. So far as online use is concerned, it strikes me as faintly odd when one compares dealing with courts with, for example, how we all now do insurance or book holidays. I mean, 15 years ago, that was all paper-based, endless telephone conversations and so forth. And now we settle down on a Saturday or Sunday morning and it's done in a flash on the computer. So the online services that we have in mind will enable litigants and also professionals who are representing litigants to do routine submission of information and documents online rather than having to fill out lengthy forms and deliver them in paper. So far as hearings where all the parties aren't present are concerned, I personally dislike the term virtual hearings because that rather gives the impression that people will be sitting at computers in rather the same way that those who enjoy gaming online can do and sit in London playing a game with someone in Alabama. That's simply not what's going to happen. Rather than virtual hearings, these are going to be hearings enabled by video and telephone. I mean, we have them already in many respects. Telephone hearings in the civil courts have been taking place, I think, for 20 years. And in the Court of Appeal Criminal Division, for example, almost all of the appellants now appear by video link rather than coming in person. But the critical thing to bear in mind is that in the event that a hearing is needed at which all the parties need to be present, that will be something that the judge decides. But many hearings don't require that. In the county court at the moment, many interlocutory hearings are conducted by telephone. And if we were to return to the system that operated when I was at the bar as a young barrister, going round all the county courts, one would travel a couple of hours each way for a 5-minute hearing. Well, that doesn't make any sense. But the important thing is that there will remain judicial control, and if the interests of justice require the physical presence of parties in court, that is what will happen.
And just what's the next category of offences that might go online? If you have traffic offences and fishing licence offences at the moment, what do you envisage for next?
Well, it's not necessarily going to be categories of cases as this project rolls out over the next few years. It will be also categories of hearings. So routine hearings which deal sometimes with listing matters, sometimes with simple bail applications, sometimes taking a plea. That's the sort of thing that we hope will not require the routine attendance of everybody at court on every occasion.
Michael Cross from the Law Society Gazette. Can we elaborate a bit more on this money for fixing these irritating and minor problems? What sort of problems are we talking about? If we're talking about spending the money, living for money within this financial year, that's by the 31st of March. And it's maybe a very different question, but why was this money sitting unspent in previous years?
Well, that I can't answer, because I can only really answer for what's been happening since I became involved. But the other questioner, when you said you'd spoken to a Crown Court judge who told you about a leak, well, that's the sort of thing that drives people mad. And it's very difficult for any court user, whether judge or professional or juror, to understand if there's a relatively minor maintenance problem, why it can't be fixed instantly. Now, the money that has been secured, and I'm enormously grateful to the Lord Chancellor for so readily signing this off, is available to all of our courts across the country. And what's happened is that the court official responsible in each court for maintenance has been asked to find projects and make a bid, essentially. And the latest information I had only in the last couple of days was that those bids were now in, and that most, if not all of them, should be able to be satisfied.
Is the money on top of the bid or part?
It's nothing to do with the reform programme. It's completely separate. Yes.
Olivia.
Hi, Olivia. There's been some discussions here about contempt of court as one of the most functional rules that could be arranged in the trials and tweeting. I think there's been a case earlier today rules about John Burnett potentially being identified on social media. Do you share those concerns, and do you think people should change the rules of society by able to deal with modern society and social media?
There have been one or two cases where inappropriate use of social media has compromised trials. And as you know, the Attorney General is seeking evidence on that matter at the moment to try to gauge whether there is anything other than a very isolated problem. But I don't accept that jurors, by and large, disregard the quite clear directions they're given. I mean, the directions given by judges relating to the use of social media have evolved enormously over the last few years. It's quite interesting. I started sitting as a recorder almost 20 years ago when such things weren't a concern at all. They became a concern, and all of us as judges said something at the beginning of a trial to warn jurors not to go online, not to share anything. But that has all been now formalised, and very clear and explicit directions are given by judges at the beginning of criminal trials. Conscious of the potential risk, at least, we commissioned work from Professor Cheryl Thomas to devise very straightforward guides and posters, effectively, to put in jury rooms to make it clear what jurors can and can't do. And so that too has happened. But we have to recognise that the way people operate generally in society changes all the time, and the ubiquitous use of social media by people is just something we have to live with. What we have to do is to give appropriate warnings to ensure that jurors understand where the boundaries are. And I've no reason to suppose that there is a general misunderstanding about that, or a general disregard by jurors of what they're told.
It's John Mann from BBC. You spoke about making transparency of the judicial system a priority, and there's been a line of course involving cameras in some sentencing trials. How's that plan gone? And are there plans afoot to roll it out nationally, and what further efforts will be taken to increase transparency in the courts?
Well, you're referring to a pilot of filming sentencing remarks, I think in 8 courts across the country. As you're aware, This was something I commented on last week when interviewed for Law in Action. The pilot is being evaluated, and it's not without some difficulty. In particular, there are two aspects which need to be looked at carefully. The first is the question of exposing judges to potential risk if these things are broadcast. And the second is the inevitable problem that I'm afraid some people behave differently, not judges, but some people behave differently in court if they know that something is being recorded. But I'm on record as suggesting that the broadcasting of sentencing remarks, at least in cases of high public interest, is something that should be looked at very carefully.
Francis.
Sorry, Francis gave from the Times. I'm sorry, I think you have covered this a little bit, but just in case, it's a different aspect. Prison overcrowding. How concerned are you about it? What should judges be doing about it in terms of their sentences that they give? Should they take account of it? And would you be against the use of court cells to ease the problem?
You're right. That was the first question I was asked, and I dealt with it at some length. And so, forgive me if I don't cover all the ground again. The new aspect that you've brought into the questioning is whether I would favour the use of court cells to ease overcrowding. Well, the first point is that although the prison population, as the statistics published by the government show, is very high, there remains significant headroom, as they call it, between the current numbers and the capacity of the prisons. So I don't think it likely that there's going to be an immediate crisis. I would not be happy for courts to be used as surrogate prisons.
Olivia, then.
You've talked quite a lot about questions on social media. You talk about how people are victims of social media abuse and physical attacks. Do you think that there's enough being done to support them in terms of mental health? Do you think more should be done? If so, what kind of thing?
Yes. Mental health perhaps puts it at a slightly alarmist level, but one of the things that we are very conscious of is that particularly for judges who spend a lot of their time dealing with the type of harrowing family case I referred to, and also those who have a fairly relentless diet of serious sex cases, it can have an impact. And so we are making available professional support to judges who feel that it would assist them. This is a new initiative that's been in development for some months now. It was in the pipeline before I became Lord Chief Justice, but it's something that I very much support. I suppose judges are fairly self-contained individuals, perhaps inevitably, given that they come from the legal profession where people tend to be quite self-contained. But none of us is invulnerable to the effects of the materials that we see in the course of our professional lives. And even as an appellate judge sitting in the Court of Appeal Criminal Division, there's some pretty shocking material that comes across our desks and which we have to take into account to be able to determine the cases before us. So it's important that we recognise that judges are human and that we put in place support mechanisms to assist those who need it.
Is that just coming in now, or is it already?
It's coming in now.
Burnett.
How concerned are you about problems with retention and sort of diversity issues within the judiciary? There's been a lot of concern that patients are putting off and paying additions are putting off younger judges, that you can't get migrant judges to follow the rules, and that women aren't making, and there's a minority judges aren't making the progress that
Well, so far as diversity is concerned, I recognise that a judiciary that broadly reflects society is likely to command confidence and respect. But the picture on diversity is in fact fast changing. Since 2010, the proportion of women judges in our courts has gone up by a third, from 21% to 28%. In tribunals, the proportion of women judges is now 45%. Those are higher figures than in the senior ranks of the legal profession from where we get our judges. One of the great strengths of the British judiciary, which I think contributes to its high standing, is that it is a second career. People come to it usually in middle age, having sat first as part-time judges. But we have to remember that the pool from which we recruit our judges, whether part-time or salaried, is the legal profession. And figures for those from non-white backgrounds also are showing substantial change. The picture in the tribunals now is that 10% of those who declare their ethnicity are from non-white backgrounds. It's a little less in the courts at 7%. And whilst that's less than the overall ethnic minority representation in the population, best estimates are about 14% at the moment, it doesn't seem to me that the overall percentage in the population is really the appropriate comparator. You really need to look at the proportion of non-white people in the legal profession, and perhaps more generally in the working population within the age cohorts where most judges sit. So 80% of judges are over the age of 50, for example, and in that age group, only 9% of the working population is from an ethnic minority. And the proportions are much lower for those over 60, for example, where many of the very senior judiciary sit in age terms. So the figures are perhaps rather better than most people would assume. And what is so encouraging is that when one looks at the age profile of the judiciary, the younger the cohort of judges, the greater the proportion of both women and ethnic minority representation.
would you see a need for maybe a second one you mentioned a sort of career judiciary, the stream of
Yes, fast track stream has shades of the civil service and those who enter from university into a fast stream. What we are doing is encouraging judges at all levels to think about their futures, and we're encouraging those who think that they are well placed to move up the ranks to prepare themselves and make applications. It's then, of course, a matter for the Judicial Appointments Commission whether the judge in question satisfies the criteria for the job that's being considered. But if you look across what's going on in the judiciary at the moment, there is a good proportion of judges who are moving from district judge to circuit judge. There are circuit judges who are moving to the High Court bench and so on. So it's not so much a career judiciary, but a recognition that there are those who have started off at a relatively modest level in the judiciary who may well have great potential. And one of the areas where it seems to me we need to be looking particularly is that the very high relative proportion of women in the tribunals and also amongst the district bench, for example, may well be a reflection that some have chosen to leave the professions, either as barrister or solicitor, and move to judicial office rather younger than might otherwise have been the case, for all sorts of reasons. And I think there is likely to be a reservoir of real talent amongst that group that we should be looking to encourage for future promotion.
Owen, John?
There are instructions I understand recently that have been issued to judges that on in criminal cases on first appearance, the nationality of the defendant has to be ascertained. Are you happy with that? It's mainly magistrates, obviously, who that's going to affect. Justice is often portrayed as lifelong. Are you happy that that's not undermining impartiality or that it's undermining confidence amongst defendants?
It's a statutory requirement, and we have to apply the law, and it would be quite inappropriate for me to express a personal opinion about a statutory requirement of that sort.
John?
Sorry, to about Brexit, but how optimistic are you that the UK and the EU courts will be able to deal with each other appropriately when Britain leaves the EU?
Well, I've absolutely no concerns about personal relationships. You'll appreciate that Brexit is at a very delicate stage, and it can't be emphasised enough that there is simply no place for any judge to be expressing any view about politics, and perhaps in particular the politics and policy surrounding Brexit.
Francis?
Notwithstanding that, your predecessor did say that judges needed guidance from Parliament post-Brexit on how to interpret the law, and he kept calling for it. Is that your view?
Yes. Well, as you know, Lord Thomas and Lord Newburger and Lady Hale, collectively and separately, I think before the Constitution Committee, asked that whatever may come out of the then bill that was in offing now before Parliament, please make it as clear as possible so that judges are not left in an exposed position. And I think it's sufficient for me to say that I hope that we get clarity.
Well, thank you very much, everybody. So we've got time for one more if anybody had a burning issue. Kathy?
That's helpful from the House Association. So it's a very general question. Possibly looking that ahead. You've all just taken off the job and said there's a huge amount to do. Is there one thing as Lord Chief Justice that you want to achieve, making the promise that you could do during your tenure?
Yes, I would like to be seen to have helped improve the morale of the judiciary.